Hi. Hello, hello. It is Amy the Attorney. I'm going to turn on a little light here. I am a lawyer that practices in Kansas and Missouri. For many years, I had a traffic practice. I am now transitioning to becoming an estate planning attorney, which I totally love because I get to help people. And that's why I went to law school. So I want to talk today about saying you say you have a trust already, that you have had another lawyer draw up a trust, but some situations have changed and or circumstances, people, something has changed materially, and you want to change the trust. And you come to me and you say, I want to change the trust. Well, that is called restating a trust. And what that means is basically I would be using the previous trust and updating it and doing what's called a restatement. And so it's a whole new document, but it incorporates the previous document and what the intentions and some of what was said in the previous trust, because it's not necessarily always that you have to change the whole entire trust. The trust itself, the original trust, might be able to, maintain parts of it, but you want to just update people. You want to update distributions of who gets what. Maybe you want to update rules about who gets what. If you had put in there prohibition on a child not receiving something until they're 30 and say they're 35 and have kids, you want the trust to reflect that. So what I do is I restate the trust, which means that I examine the previous trust very thoroughly. I we have I have several conversations with the client to determine what exactly they want changed. I then make a draft of those changes. The client and I discuss those, and then if it's okay, then we will get the trust notarized with the trustee. Or if there's changes to be made, I make those changes, and then we get the trust notarized with the trustee. So it is possible. There are some problems. People complain. Lots of lawyers don't want to restate trust because they don't want to take in somebody else's work. Some other lawyer made that original trust. We don't know whether to trust that other lawyer in their competency and in their ability to write a trust. So there's some issues there. And also, one of the issues for a client is when we say, okay, we don't want to restate the trust, we want to just draw you up a whole new trust. One of the big issues with clients is they have named all of their assets for the trust in in the original trust name. So say if you have the John Doe Trust and you've entitled your bank accounts, you've entitled real estate, you've entitled brokerage accounts, whatever, oil wells, other possessions that you have in that trust name. If I give you a whole new trust, it gets a whole new name and you would have to go back and retitle those. So I understand that. In my situation, what I do is I charge by the hour for restating trust. A lot of my business is done flat fee, but for restating a trust, I charge by the hour. And that includes reviewing the original trust and really getting to know the language in there so that I can correctly restate it on the restated trust. So that is restated trust in a nutshell. I hope that if you have a restated trust, if you need some trust updated in Missouri or Kansas, that you call me and I would be happy to look at them, review them, and get them to where you want them to be. All right. Thank you so much. This is Amy the Attorney.